Ready.
Jason, you ready?
Yeah, I'm ready.
Sure. All right, this time we'll call the October 13th, 2025 special meeting of the East Hempfield Township Zoning Hearing Board to order. This meeting is continued from the October 2024 special meeting on case number 2476, Colebrook Associates Venture LLC. Members of the board who are present this evening are Mr. Bingham, Mr. Kyle, Mr. Luce, and myself, Mark Hanson, Vice Chairman to the board. Also for the record, we have Nate Sturgis, Director of Planning for the township, as our zoning officer is off tonight. And our legal counsel, Attorney Jason Hess, as well. We also have a court reporter with us. Schedule this evening is this continued case, and any old business may come before us this evening. This board will hear each case in an informal manner without strict compliance with the rules and procedures used in a court trial. We ask each applicant and any individual interested in a case to step in front of our table, explain the circumstances involved in their application. Applicants may present their case themselves through their attorneys or any other representatives. My fellow board members and I, as well as our solicitor, may ask the applicant questions from time to time during the applicant's presentation or at its conclusion. All persons having an interest in the application will be given the opportunity to ask questions to the applicant, offer evidence of their own, and inform the board of their position on the matter. In the interest of prompt and orderly disposition of each case, however, we ask that interested people refrain from speaking until the applicant's presentation has been completed and the board has an opportunity to question the applicant. At the beginning of each case, people who are interested in the case should decide whether they desire to be a party to it. By giving the status of a party, that person will be entitled to receive notice of the decision in the case and be entitled to participate in any subsequent appeal or rehearing. Individuals who are not given party status may nevertheless ask questions or present evidence, but will not receive notice of the decision or will not automatically be entitled to participate in any appeal or subsequent rehearing. If you desire to be a party, we ask that you sign an entry of appearance form at the appropriate time. Although each party will receive a written copy of the decision, the mechanics of typing and signing the decision will take approximately 4 weeks. We ask that each person who asks a question or makes a statement first state his or her name and address for our court reporter. Lastly, in the interest of time, I will minister the oath or affirmation to all applicants and to everybody and anyone who anticipates making any statement with respect to any of the hearings this evening. At this time, will you all please rise? Under penalties of perjury, you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. If so, please say, I do. Let's remain standing. We'll salute the flag. Pledge allegiance to the flag of the United States of America. And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Also, just to let everybody know, this meeting is on Zoom. Nate, do we have anybody on Zoom?
No, we do not.
Okay. Nate, has the case this evening been posted and advertised in accordance with the sunshine law and the ordinance?
Yes, they have.
Okay. Gentlemen, you have received a copy of the October 17th, 2024 board minutes as presented by our secretary. If there are no deletions, additions, or correction, I ask for a motion to approve the board minutes as submitted.
So moved. Second.
Moved by Mr. Luce, seconded by Mr. Bingham to approve the minutes as submitted.
Hanson, I just want to know my last name spelled incorrectly. It's K-I-L-E. I would just note that on there. Throughout the, looks like it's spelled incorrectly throughout.
Glad you recognize that.
Okay,
So,
we'll accept.
feel remiss in not noting that on there.
My name's hard to misspell.
Well, I think Motion is made, seconded with the changes as listed by Mr. Kyle. Mr. Luce,
In favor?
Mr. Kyle,
In favor?
Mr. Bingham.
In favor.
I will also vote in favor. The minutes have been approved. Normally, we would not conduct any other business at a special meeting. However, because we're up against the 45-day time limit for our decision, we will be making a decision in case 2492 this evening. Jason, I'm going to turn it over to you.
Okay, thank you. So the case, case number 2492 was an appeal from the enforcement notice issued by the township to Landisville Lofts LLC. And it was regarding the storage of a couple trailers on in the parking lot of the property. Hearing was held last month, the September 15, 2025 meeting. And at the conclusion of the meeting, the board voted to take the available 45 days to make the decision. And as permitted by law, the board is able to speak with counsel and deliberate as a quasi judicial agency, deliberate in private over the decision, which I had the opportunity to speak with the board members since the last hearing. And based on our conversations, I was able based on those conversations, I was able to come up with a written decision, which the board, if they do vote to approve that after I'm done, would be the decision of the board. So just going to and copy of the written decision that was prepared based on our conversations. And ask if there is a motion based on the written decision that was prepared containing 37 findings of fact, containing 16 conclusions of law, and an order, which I'll just read into the record at the end, saying, based upon the foregoing findings of fact and conclusions of law, the zoning hearing board of the Township of East Hempfield hereby denies the appeal filed by appellant Landisville Lofts LLC with respect to property at 335 East Main Street and upholds the enforcement notice issued by the township. So I'll ask the board now if there's a motion.
Mr. Chairman, in case number 2492, I move to deny the appeal of the Landis Lofts LLC from the enforcement notice issued by the Township Zoning Officer on July 9th, 2025, and to adopt as the decision of the Zoning Hearing Board the 37 findings of fact and 16 conclusions of law and the order contained in the written decision presented at this meeting consisting of 7 pages.
Gentlemen, motion made by Mr. Luce to deny the appeal of Landisville Lofts LLC from the enforcement notice issued by the township officer. Do I have a second?
Second.
Any discussion? If not, Mr. Luce, how do you vote?
In favor?
Mr. Kyle?
In favor?
Mr. Bingham?
In favor.
And I will also vote in favor. Their appeal of the Landisville Lofts LLC has been denied. All right, Nate, will you call the continued case, please?
All right, case number 2476, Colebrook Associates Venture LLC. The applicant has amended its application to request variances from the following sections of the East Hempfield Township zoning ordinance and the alternative to the substantive validity challenge to allow a proposed 204-unit expansion of the Colebrook apartment development on the property. Section 270-3.6 E3D to allow a maximum density of 8.62 dwelling units per acre. Section 270-3.6 E6A to allow building height of 50 feet. Section 270-3.6.E7A to allow a building area of 18,000 square feet. And 270-9.1.D13E to allow up to 2 years to obtain preliminary land development approval for the apartment expansion project.
Okay. Now, normally, when we have a case where the applicant asks for amendment that changes so much from their original submission, we wouldn't hear the case, we'd make them reapply and go through the whole process again. However, because of the letter sent by Mr. Noggle on September 25th to the township, and because it was properly advertised, we're going to allow you to request to amend the application. Just to bring everybody up to speed, there have been 6 special meetings so far in this case. They are March 21, 2024, April 18th, 2024, June 20, 2024, July 18th, 2024, and September 19th, 2024, and the last one was October 17th, 2024. Along with those, in those meetings, there were 50 exhibits that were submitted for the applicant. Bringing everybody up to speed, I'm going to turn it back over to Jason.
Okay, thanks. So, and I think those 50 exhibits, I don't think they were formally admitted by the board yet. They were submitted, and I think it concluded before the township began its case, if I'm correct. And so based on the letter from applicant's counsel September 25th, would be 4 additional variance requests, and I can let the applicant explain what those are. But after you explain what the variance requests are, and the board has any questions, and they'll have to vote on whether to allow the amendment. They need to formally vote on whether to allow the amendment prior to moving on with the case. So if you would like to go explain what the amendments are, and then if the board has any questions.
Just a brief explanation of the variance request.
Good evening, Brian Nagel on behalf of the applicant. Just in summary, we've come up with a minimum relief plan to resolve issues that were raised by the applicant and that were presented to the board at the prior hearings that Mr. Hanson referenced a moment ago, while also limiting the relief from the zoning hearing board to the greatest extent possible. The township does not object to the minimum relief plan that you'll see shortly, provided that certain conditions are imposed by the zoning hearing board together with the dimensional variances that are being sought in the alternative, which Mr. Sturgis just referenced. Those conditions are listed in my September 25th, 2025 letter of amendment that Mr. Hanson referenced a few minutes ago. And provided that the dimensional variances are granted, my client has no objection to those conditions. What I would intend to do is call Mr. Best, our civil engineering expert, to walk through the plan as well as those dimensional variances briefly. If you'd like to give me to give you a summary of what the variance relief is before you consider the amendment, I'm happy to do that.
So you're asking to amend the application to allow a variance for maximum density, section 270-3.6E3D. Variance to the maximum building height, section 273.6E6A. Maximum building area, section 270-3.6E7A. And it's variance to section 270-9.1D13E, is that correct?
That is correct.
And then if the board were to grant those variances, you would drop the request, for the, where to go? Your request to change the ordinance, correct?
That's correct.
Okay. Gentlemen, you heard Mr. Nagel's request. Do I have a motion to amend their application? Do I have a second? Okay, gentlemen, we have a motion and a second to amend the applicant's application in case number 2476. To add 4 variance requests. I'm not gonna repeat them, but I just went over them. Any discussion? Mr. Luce, how do you vote?
In favor.
Mr. Kyle?
In favor.
Mr. Bingham?
In favor.
I will also vote in favor of your your request to amend the application as.
Thank you.
Okay, so before we continue, in your letter, you noted the township had no no objection for the variances. Not having seen anything in writing or anything like that, Ms. Piper, I'm gonna ask you to explain the supervisor's position on it.
Sure. So since your last meeting in October of 2024, there have been conversations with staff and council about the plan that has been presented. The township has worked with the applicant. The applicant has proposed the plan that they intend to present to you tonight. The township has no objection to the variances being requested, provided that any approval is subject to the conditions set forth in council's letter. Those are conditions that have been negotiated between the applicant and the township.
That was 6 conditions.
That is correct. Yes.
All right. We're all up to speed, Mr. Nagel.
Thank you. The applicant will call Mr. Best.
Up there. Please speak into the microphone.
I have some pre-marked exhibits. I've already given them to council, if I may distribute them. Mr. Best, you previously presented a 308 unit multifamily development plan for the property as a relief plan under the application that was pending prior to the amended application this evening, correct?
That's correct.
Have you more recently prepared an alternative plan for the property that you would consider a minimum relief plan?
Yes, I have.
And that plan requires 3-dimensional variances, and there's also a request that we mentioned a few minutes ago about an extension of time frame provision under the township zoning ordinance, correct?
Correct.
I'm showing you an exhibit, 2-page document marked exhibit A52A and A52B. Could you please identify what those plans are?
Exhibits A52A and A52B are different views of the same plan, which is the, what you're referring to as the relief plan. 204 units. 204. 204.
And using either of those 2 exhibits or both, if you choose, could you walk the members of the zoning hearing board through the layout and the distribution of the dwelling units contained on those plans?
Certainly. The plan that we're looking at on screen is A52A, which is a zoomed out version that shows the proposed 204 units in the context of the greater Colebrook Apartments development and the surrounding properties. And that is located to the upper left of the screen. There's an area that's sort of surrounded by a bunch of evergreen trees there, but the proposed development connects to the existing development by 2 roads that you see. I do not have a pointer, I would actually indicate that.
Thanks, Dan. Yeah.
Thank you. There we go. So my pointer is now circling proposed portions of the Colebrook development, the 204 units.
And is it fair to say that this plan maximizes the open space on the site and minimizes the number of dwelling units and impervious coverage while still allowing relief under the zoning ordinance?
Yes, it is. This plan is about as efficient as it can be while maintaining the number of units that were needed to promote the plan to be viable.
Can you please look at the document marked A53 for identification? Do you recognize that document?
I do, yes.
Could you identify it, please?
Sure, this is the letter that was sent to the zoning hearing board solicitor by Mr. Nagel, Attorney Nagel. That requested the amendment to the application to allow consideration of 4 variances.
And do you see the 3-dimensional variances that we referenced already this evening listed on the first page of that September 25th, 2025 letter?
I do, yes.
Did you assist in determining the sections of the zoning ordinance from which dimensional variance relief would be required in order to implement A52A, the plan shown in A52A and A52B?
I did, yes.
Could you just briefly walk the members of the zoning hearing board through each dimensional variance, 1 through 3, listed on that letter?
Dimensional variance, number 1, for maximum density, section 270 3.6E3E. The ordinance permits up to 5 dwelling units per acre in the zone that we're working with. The applicant's 204 unit plan, this plan that we're now reviewing and looking at on screen, is requesting an additional 3.62 dwelling units per acre for a total of 8.62. Mathematically, that works out when you add 204 units to the existing 342 units, which combine, for the total that we're proposing and existing, and then divide that by the gross acreage of 63.321. So 8.62 dwelling units per acre is what we're seeking in total. The relief required would be 3.62 dwelling units per acre.
That's one.
That's one. The next one is for maximum building height. The maximum building height permitted for principal structures is 35 feet. This 204 unit plan proposes elevator served 4-story buildings that would have a maximum height of 50 feet, which is a variance of 15 feet beyond what is permitted.
That's 2.
That's 2. 3 is the maximum building area. The maximum permitted building area for multifamily dwellings is 10,000 square feet floor plate. The applicant's 204 unit plan that you're now viewing on screen is showing 18,000 square foot building footprints for a variance of 8,000 square feet.
And then the fourth variance that's included on page 2 of that letter you're referring to is an extension of the time frame for the implementation of variances that would potentially be granted by the zoning hearing board. And I assume that's due to the complexity of the project at hand.
Correct, yeah. Should the variances be granted, this variance request is important because it is a complex project and we're gonna need time to work through land development. And obviously there's a lot to do before we do that, with survey and so forth. So I think it lays out that we're requesting 2 years from the date of issuance of the zoning board's written decision in order to obtain preliminary plan, land development plan approval, and then another 2 years from that approval date to actually obtain the first building permit.
Are you also familiar with the conditions that are listed on the balance of page 2 and the top of page 3 that were requested by the township as conditions that be imposed by the zoning hearing board if the zoning hearing board grants the dimensional relief? You mentioned that the 204 plan that you reviewed, 52A and 52B, is a minimum relief plan. Can you explain the implication of the conditions and whether those can be implemented in your opinion?
I'm looking at the conditions now, just to make sure I'm not speaking out of turn. So the first one deals with the reconfiguration of Old Horstown Road. And yes, this is something that the applicant has agreed to do as part of the relief plan. That is something that, yes, we can accommodate.
Isn't it fair to say you've reviewed all of these conditions previously and confirmed that the applicant can implement them?
Yes,
Subject to full land development approval in coordination with PennDOT with respect to the Harrisburg Pike and Roarstown Road reconfiguration?
yeah.
And can you review exhibits A54 through A56 and just explain what those are briefly?
Yeah, A54 and A55 regard as variations on the same theme. So I'm gonna lump those together as I talk about them. These are two concepts for the realignment or reconfiguration of Old Roarstown Road. That were prepared to demonstrate what would be necessary to align Old Roarstown Road such that it directly opposes L.H. Brubaker's driveway on Harrisburg Pike. When I say L.H. Brubaker's driveway, I'm referring to the one that actually gets utilized. They have another one further to the west that is blocked off and not utilized. And understandably, this concept would be devastating to the Westgate Baptist Church. They wish to remain, and so these two concepts, 1 and 2, are really not viable. But they needed to be prepared to show that we could actually develop a concept that would regard the most favorable location to connect that Old Roarstown Road alignment with. So discarding these two, we came up with the third one, which is exhibit A56, which seeks to realign or reconfigure Old Roarstown Road in a way that maintains the church and aligns the center line across from L.H. Brubaker's westernmost driveway. And what this does is it accomplishes that by skirting the church building and its parking to the south and west, or north and west really, connecting to the southwest of the church building. It begins doing so by creating a 4-way intersection at Landon Way and Old Town Road and seeks to develop a cul-de-sac, public street that would afford access to some of the quote unquote orphan properties along the original path of Old Town Road.
In the event that the variances are granted, that would be subject to a land development application that would be filed with the township, correct?
Certainly, yeah, there's gonna be a lot of eyeballs on this from a technical perspective.
And in addition to review by the township, there would also be an application with PennDOT for this as well, correct?
Correct,
So it all remains subject to those reviews.
yes, it does.
And condition number 1 on page 2 of the amendment letter also refers to these improvements that you're showing on the plans you were just referring to as improvements that would ultimately be dedicated to the township as a permanent traffic improvement with regard to the relationship between Old Town Road and Harrisburg Pike, correct?
Correct.
One question quickly. The drawing we're seeing, what are the long dash lines there? Is that the floodplain or what is that?
Which ones, let me get my one. Are you referring to these long dash lines?
Yes.
That is a rendition of a floodplain that would need to be confirmed. That was probably GIS based.
Okay.
So if there is a detailed study, we would need to implement that.
Okay, thank you.
Would you agree that based on the minimum relief plan and the details that you've reviewed this evening, that the variances that you reviewed tonight meet the hardship standards under Pennsylvania law in terms of the property cannot be developed under the existing zoning, the hardship's not created by the applicant, and the plan is the minimum relief that will allow reasonable development of the property under the circumstances?
I do.
I have no further questions for Mr. Best.
I do have some questions. Mr. Best, turning back to Exhibit A 52B, which is the larger site plan. One of the conditions that has been proposed is that the property will be developed in substantially in conformity with this plan submitted as part of the application, including the conceptual layout of the buildings and the associated features. Could you walk us through what the associated features are with this 204 unit plan?
Yeah, I apologize. This wasn't up when I was looking at the 204 unit and large, 30,000 foot view. We have a cluster of 4 elevator served 4-story buildings, and 3 of those include 58 units. The 4th one, the one that's central to the 2 access drives, has 48, but it also has amenities on the first floor that would include things like a leasing office or some business space, and so forth, meeting rooms, that kind of thing. These are arranged around a central courtyard, which, as you can see, has a lot of green space, but also includes a pool and some shade structures, some areas for residents to gather, perhaps some picnic areas, grilling, that kind of thing. Parking is generally at the periphery to keep this all as a pedestrian-oriented inward space. And at the periphery, we have a walking trail that snakes its way around that is just over a half a mile in length as a loop. We have community gardens for the residents of these 4 buildings right here on the lower left, and adjacent to those 4 pickleball courts as well.
Okay. So it's the developer's intent to provide all of these amenities with this new plan. Okay. Turning then to the access and the concepts 1, 2, and 3. I want to make sure I understand your testimony. Are you suggesting that the church will not relocate at this point?
It appears not, no. They are interested in staying where they are, but they have expressed an interest in working with the applicant to, provide for the land that's needed to accomplish, the goals of, reconfiguring Old Town Road.
Okay. And then your concept number 3, which is marked. Yes.
Mr. Best, so 856 is the preferred reconfiguration. Right.
That is correct.
Thank you. Go ahead.
Okay, thank you. So taking a look at 856, if it's determined during land development that that cul-de-sac that is proposed is not suitable to the township, the developer would be willing to redesign that access point?
Yeah, I think that's something that we can get into with the planning department.
Okay. And your client understands that the actual current point or intersection of Harrisburg Pike and Old Town Road, what happens to that will be negotiated with the township during land development. Is that
Yes.
okay? Condition number 3 in council's letter talks about coordinating to pursue a trail from the new access point at Harrisburg Pike to the property. Is that something that your client is willing to include as part of their land development plan?
It is, and in fact, we are showing a trail on this option 3B. So there is I think it's an 8-foot wide or 6-foot wide, I don't remember which pathway, whatever was discussed with the staff, I'm sorry. I don't recall the dimension, but we are showing that beginning at Harrisburg Pike and following the path of the reconfigured Old Town Road, where it turns north and goes up the actual existing Old Town Road. We recognize that crosses the bridge on Swar Run, and we also recognize that is to extend to the northern entrance. I never remember if that's 12 Drive or Denby Way.
Condition number 5 speaks to resolution of ongoing washout issues on the west side of Old Town Road between Welsh Drive and Tenby Way. Can you speak a little bit to what that's about?
I don't know what the source of it is, but yes, there are some areas along the frontage of Colebrook Apartments that is clearly being scoured by stormwater. Obviously, we'll have to dig into that, but we do understand it's a problem and that it needs to be addressed, and the applicant has agreed to do so as part of this effort.
Okay. And finally, condition number 4 speaks about an easement for a future trail along a portion of Swar Run that abuts your client's property. But your client would not be required to actually construct the improvements, but is it correct that your client would be willing to grant an easement to the township for that? Okay. Just give me one moment. Okay. All right. Thank you. I don't have any further questions.
So, comment 5 on the conditions that we just spoke about. And either the applicant or the township clarify the ability to go after, I guess, property owners for reimbursement contribution. I'd like to understand that, or what that's gonna be, or what that's proposed to be. That's what I have a concern about that.
Yeah, it's the township's understanding that that is on the applicant's property, that washout area.
So we're not concerned about the comment that they pursue each other responsible. That applies. I know what it implies, but I'd like to understand a little bit more why.
Well,
I think what you're picking up on is that reference refers to what Mr. Best testified about, which is we don't know exactly what the source of that washout really is. And so until that is determined, it's just really essentially a reservation of rights. My expectation is that ultimately it's nothing more of Mr. Best's office is gonna be analyzing that as part of the land development application and how the washout can be repaired during the land development process. But at the same time, if there's an offsite issue that's coming from some other source, let's say, for example, like a point source discharge from another development, we need to be able to go to that property owner and say, we're fixing this issue as we're required to, but we need to make sure that the fix we put in isn't going to be under duress or unreasonable duress because you have some illegal stormwater runoff or something like that. So that's really all that's referring to. But as between the understanding between the township and the applicant and the expectation is that that issue is going to be corrected during the land development. We just had that reservation in case there's something to that nature.
No, I fully understand being corrected. That's just clarification for me, and I guess the township can handle that. That's the. One other question pertaining to the 2 years for the preliminary plan approval. That seems generous to me. I mean, that's the minimum that is needed by the applicant.
We think it is. I don't think the township disagrees with that. I mean, this, especially with the PennDOT element to this project, it's time consuming.
Understood.
You know, most of the time nowadays, I'm not sure what the term, the solicitor sees, but I see 18 months as the minimum time allowance for a land development application. So 2 years in a more complex PennDOT issue is actually pretty tight as far as I'm concerned.
So I'm gonna jump on that. Glad that question also of mine a little bit expanded on that. I understand the 2 years for the preliminary land development plan. And I understand, I have worked with the county on some of their committees working with PennDOT, how much of pain that can be. My question is, after you obtain preliminary plan development approval, why do you need additional 2 years for your build permit?
Because once you obtain preliminary land development approval, then you're going into finalizing your PennDOT approvals, your stormwater management approvals, the agreements with the township, plus design. At that point, you're free to go ahead and release your architect to design the building permit plans, which for a project like this takes some time. So all of that other stuff just, time goes quickly. And if it's shorter, it will be shorter, but we sort of spec'd out what we thought would be a realistic time frame. And if we can't hit those timeframes, we'll have to come back to the zoning hearing board and ask for more time, but we wanted to build in what we thought was realistic.
Once you've got your 4 years, and you've got everything ready to go, don't they have a year to complete construction?
There's no requirement.
That used to be, there used to be.
There's a requirement for pulling permits.
Right. You have any other questions?
Not at this time.
Mr. Bingham, any questions?
No.
All right, I got a couple. Mr. Best. This new plan goes to 8.62 units per acre, correct? Back in March of March 22nd, 24 meeting, Mr. Polanski testified 5 to 8 would not work, would not make it viable. He thought 10 to 12 is more realistic. What does it?
Negotiation, I think we would have preferred a lot more. I think at this point, they're recognizing that they have little choice but to move forward with something that is really tight.
Well, and I think Mr. Samuels also testified to that 5 to 8 just wasn't financially viable to build. And you're only going slightly over 8 here. They just both testified 10 to 12 or more would be more financially viable.
I can't speak to the financial piece of it, but I can can tell you that the building typology this time around has changed to something that's probably a bit higher rent. And therefore, some of those financial hurdles are overcome with anticipated revenue more than would have been the case with the typologies that were proposed at that time.
I have a question on condition number 2. Township and the applicant shall coordinate and cooperate pursuing any grant app. What type of applications would they receive?
Most likely, there could be stormwater or stream restoration, but most likely we're anticipating road improvement applications.
This fiber, the number 4, I'm assuming the grant for easement is to continue the trail that's being built down along School Run.
Yes.
I have no question this time. Jason?
Give me 1 second here. With respect to the first condition, it's just the option, the third option, which is the only viable option, I guess, at this point, would be submitted to PennDOT for approval. But if it's not, if approval is not part of the problem, then if approval is not forthcoming, then we'll override on road safety.
Now, I don't anticipate that to be, if I think PennDOT's expectations would be that the issue there get corrected somehow or another. So my expectation is they will find an option that works, because whatever it is in this window of options we're looking at here that we see in these exhibits is going to be an improvement, I think, from their perception. And Jason, would you agree with that?
I would. The existing condition without this additional 204 units is already not desirable in PennDOT's eyes, because the Georgetown Road, Harrisburg Pike, in the middle of the left turn queue to turn north on Governville Road. That is a bad situation, and it's one that PennDOT's going to be eager to address.
So it's an option, but it might get tweaked based on PennDOT's feedback, and the township and the applicant are going to have to work with PennDOT to get an acceptable resolution there.
So it could be option 3 or something slightly different. Anyone?
Correct. I mean, I think the condition contemplates, and we need to maintain that all options are still a possibility, even though we know that the church would like to stay, and that's what we're going to try to facilitate, and we think we can.
I believe that's
Follow up on it. The township is okay with option 3.
Yes, the concept, the details need to be worked through.
And that's similar to what was presented back at the original parents' request for this application, correct?
It is. It's similar.
Okay. Gentlemen, any other questions? Nate, any questions?
No questions.
And
Mr. Chairman, I'll just say that, ordinarily the board would close testimony before taking a vote, but it should be, there is, the applicant would like to proceed with their original request if the board were denied to deny the variance. So I think, although it's a little bit unorthodox, the record should not be closed at this time. Does council agree with that?
Yes. And we would also ask for the admission of the exhibits that were presented this evening, and also only in reference to the dimensional variance request. I think I would say the admission of any exhibits that were presented previously that the ZHB feels like it needs to rely on. Only for purposes of the dimensional variance request.
Go, you have what?
Yeah, can the applicant just clarify what conversation, if any, you formally had, and not, you never talked about the intersection of the project, or?
There hasn't been anything formal with PennDOT at this time, no.
The township has had any conversation with PennDOT about this?
No.
All right, Mr. Long, we have anything else to add?
I do not, thank you.
I do not have any testimony.
I'm gonna take a 5-minute recess so I can talk to council.
Right. They know this one. Okay, so this one here was. Okay, yeah. So it'd be this, well, it would be the two. And then this is.
Don't
Sheet is closed.
you guys have that? And so, going off the record, for the record. Where we at?
So this is called Slaton's. Freewheeling, and this one too. Also, yeah. Where it depends. Right. I'm guessing there's gonna solve that in a second.
In E, for the modification of 2 years to obtain developmental approval and an additional 1 year to obtain the first building. With that, I'd also like to attach the 6 conditions that were stated and presented by the township.
Statement by the applicant that the township.
There you go.
John, we have a motion by Mr. Luce, case number 2476. Grant a variance of section 270-3.6 E3D to grant a 3.62 units per acre variance for a total of 8.62 dwelling units per acre. The variance of section 270-3.6 E6A to grant a variance of 15 feet from the grant a variance of 15 feet in addition to grant a variance of 15 feet to the building height from 35 feet to 50 feet. Section 270-3.6 E6A to grant a variance of 8,000 square feet from the 10,000 square foot allowable building area of multifamily dwelling, bring the total to 18,000 square feet. And number 4, to extend the time frame the variant section 270-9.1 D 13E to allow for 2 years. The applicant have 2 years from the date of issuing the zoning hearing for a decision to obtain a final land development plan based on PennDOT's approval, and 1 year to obtain its first building permit for the project. Additional time is needed, the applicant needs to come back before this board to ask for more time. So you have 3 years total.
And the understanding is that it could be conditioned on PennDOT's approval, correct?
I was gonna, yeah, amend that to say conditional final.
Conditional final, and then that say conditional final based on PennDOT's approval.
And any other conditions of township.
And then, with the 5 or 6 conditions that are listed in the applicant's letter dated September 25th, 2025. And those conditions just quickly are the options of redoing Old Wartown Road. 2, pursuing grant applications. Number 3, access point for trail on Old Wartown Road. 4, easement for future trail on the Swore Run. 5, the ongoing washouts issues on the west side of Rivertown Road. And number 6, the subject property will be developed substantially in compliance with 204 unit plan submitted as part of nice testing and our standard conditions. Is that your motion?
Yes, we gotta go.
Do I have a second? Any discussion? Mr. Luce,
In favor?
Mr. Kyle,
In favor.
Mr. Bain?
In favor.
I will also vote in favor. Your variance requests have been granted, as stated just now. Now, that is out of the way. You are withdrawing your validity challenge, correct?
Correct, subject to the issuance of a written decision confirming the decision of the zoning hearing board tonight. The balance of the application on the validity challenge is withdrawn.
You also enter into the record the exhibits as listed that were presented tonight.
Thank
You
you.
will not enter the rest of the exhibits from the previous meeting because you're withdrawing validity request. Anything else, Jason?
I don't believe.
In that case, this meeting is adjourned.
Thank you for your time.
Thank you.
You.
Appreciate it. Just for you guys, this morning, we don't know if there's gonna be another meeting.
All the days.
That,
Love the days.
Thank you. You know.